Good morning, everyone. My name is Richard Ponte, and I am the Director of Events and Programs for the Maine State Chamber of Commerce. On behalf of the entire team here, it is my pleasure to welcome you to the third session in our series on employers navigating immigration and workforce compliance. Today's focus will be on workers with temporary status. Thank you for joining. Before we get going, there are just a few things we'd like to share with you about today's session. All participants are in listen-only mode. Please submit questions using the Q&A function. Time permitting, we will answer them by the end of the session. We will also use the Q&A feature to share useful links and other materials. We have enabled closed captioning in English. You can access this feature by toggling it on the taskbar at the bottom of your screen. This meeting is being recorded, and we will make the recording available to you on our website in the coming weeks. And finally, if you lose your connection, please use the same Zoom link to reconnect. We would now like to begin by thanking our sponsors. Our 2025 webinar series sponsors are AARP, Bangor Savings Bank, Kennebec Savings Bank, MEMIC, Merrill's Investigations and Security, Northeast Delta Dental, and Summit Natural Gas of Maine. It is now my pleasure to introduce the President and CEO of the Maine State Chamber of Commerce, Patrick Woodcock. Patrick will be moderating the conversation today. Good morning, Patrick.
Well, good morning, Richard, and thank you all for joining us for our third in our series of best practices for compliance with immigration. It has been a wealth of information. We're so appreciative of Katie Minervino, who leads the practice group of Pierce Atwood on immigration, providing this information that is timely. I did want to say today's content is one that is particularly urgent with changing temporary protected status and builds on a presentation we did earlier this year. I did want to further remind all the employers who are with us this morning that there is an opportunity that the Maine State Chamber is looking to offer employers and employees for English language services. I was on the advisory committee yesterday with the Office of New Americans, where they spoke about the importance of integrating and advancing skills of English language for immigrants in our population. It was a scale that was very surprising to me of how many uh, immigrants need these services and what the gap is for funding to provide them. This will be a free service for roughly 150 employees. If you are interested in this, we'll be rolling this out formally in the next couple weeks. Next week, we will have a presentation from NGen to explain the expectations and the offering for interested employers. But if you are interested in learning more, this will be a limited amount of space. Please do reach out to Mark Ellis. With that, I wanted to introduce again Katie Minervino, who will take us through temporary protected employees and best practices for navigating those employees. Katie?
Thank you, Patrick. Thank you for everyone who is attending today and has attended the other sessions. I will come back next week as long as everybody promises not to judge me if you watch closed caption at any point and hear how many times I say for the course of the presentations. Today is a little bit different than the prior 2 weeks. In the first and second presentation, we focused primarily on the Form I-9, which relates directly to this presentation. But today we're going to talk about issues that employers are facing when they're thinking and they are hiring foreign workers. And the agenda is that we're going to talk, we're going to kick off with a conversation just thinking about U.S. workers to avoid some common pitfalls and how we, think about who's a U.S. worker, who's not a U.S. worker, and what employers should be doing. We're going to revisit, I promise, very briefly, Form I-9 and the employer's role. We're going to talk about categories of work authorization, give some general high-level overviews of the types of workers that employers may be able to hire in the United States. we're going to have kind of a deeper dive and a discussion around what employers can, should, and may be doing in terms of identifying sponsorship needs on the front end, kind of being able to identify if someone requires sponsorship in the application process, planning for that, managing that, thinking about what we mean for sponsorship. And then thinking also around changes in work authorization, avoiding liability. And one of the themes, as Patrick touched on, and that will come out, especially in some recent development, is that generally if you have individuals who have temporary work authorization, that work authorization is, it's temporary, it's short term, it needs to be re-verified, and it's fluid in a few different ways. So there are, points where employers need to kind of redo the I-9 re-verification, check in with employees, and might need to take action also, even if the I-9 is still valid, if they acquire knowledge that someone may not be authorized to work. And we're going to talk about that in some detail, and then leave some time for questions. I will monitor the Q&A over the course of this presentation and be able to answer, as I can while we're going. So we'll go from there. So, as you're kicking this off, like, let's just thank you if you think like, okay, this sounds kind of stressful. We're doing a whole 90 minutes about it. Would it be possible for me to avoid any of the risk around re-verification, compliance, thinking through sponsorship needs by just saying we're going to hire US citizens only? My company, we don't hire a lot. We're not in a position that we could ever sponsor. We have a kind of limited HR function. Can we manage this and say like, nope, we're just going to hire US citizens? And I want to flag initially, in a very bright line, that employers cannot across the board just say they're only hiring US citizens. And this quote here is from the Department of Justice Immigrant Employee Rights Group. But the bottom line is that there are some jobs that have to be US citizen only jobs. That's true. So there are, kind of federal employees, there are positions where you can only hire US citizens. If that's the case, then you can and should comply with that requirement and understand it. There's, risk, and it's discrimination from the employer if they say a job can only be filled by US citizens and it is not legally required that it's filled by US citizens. And a very important thing to think about is that the definition of a US worker is not only that of a US citizen. A US worker is someone who, under the Immigration Nationality Act and the related regulations, would include US citizens, lawful permanent residents, and also asylees and refugees. These are people who are able to work on a permanent basis in the United States without an employer sponsoring, without any additional work authorization applications. They are authorized to work. And I mentioned this on the outset because this is easy to get confused and it's easy to mess up, especially for employers if they, kind of are really looking to limit the kind of just the consideration around this. And if there's something that goes online, it's easy for employers to get in trouble about. So if you are, for example, kind of posting a job ad and you say you don't want to sponsor for the job and you say US citizen only, that's low hanging fruit for the government to potentially bring a discrimination charge because you have publicly posted on your website a restriction in terms of the type of workers that you would hire that is not in compliance with the law and is kind of in writing on your website out in the public. So I mentioned that just as a starting point because I want to make sure that kind of if you come out of this and think like that's a lot, how can we make this easy? You want to be careful around kind of these restrictions. And I see kind of frequently job postings, communications, and a lot of it might not. A lot of it I know is not intentional. There's not intent to discriminate. A lot of times the employer would hire a green card holder, would hire an asylee, but you want to make sure that you're thinking about your US workers more expansively than citizens only. And if you are going out to market and saying that your job must be filled by a US citizen, you understand the position and any requirement that gives you the basis to do that. And you're ready to articulate the same as you go forward. So, kind of back to IRCA, back to the Immigration Control Reform and Control Act. So the government in 1986 said we are going to, essentially, as I said in the first presentation, deputize employers to make sure that our workforce is legal. So we have the Immigration Reform and Control Act, and the Form I-9 is a product of this Immigration Reform and Control Act. So the core requirements are that employers verify employment eligibility, you can't discriminate, you can't retaliate, and you have to, kind of check the employment verification of every employee that's hired after November 6, 1986, and this applies to all employers. So, as we talked earlier, employers are essentially the, kind of the gatekeepers of making sure that the people who are on their workforce are work authorized. And that is, kind of an ongoing obligation in some cases, where if you have somebody who presents short-term work authorization, the employer is obligated to check in when that document expires on the Form I-9 and say to the employee, our records show that your work authorization is expiring. We'll take any documentation of your choosing to show that you can continue to work. We just have to see and document. This is part of the federal law. I need to make sure that I have ongoing evidence that you're employment authorized. We need to re-verify you by the date that we understand that your status ends. Normally it's going to be the date on the form. Sometimes employers have to do it earlier than the date on the form if they have knowledge that somebody's status has changed. If somebody comes to you and says, oh my gosh, like, I had this status, but I lost it, here's a different work authorization. Or, if somebody's even in the period of their Form I-9 and they lose their work authorization for one reason or another, then, that might be a case that you re-verify. And if the individual does not have continued work authorization, then you need to terminate the employment authorization for a current employee. Our next presentation next week is going to talk about kind of like really when the rubber hits the road. If you have the immigration agencies that are in charge of enforcement coming on site, checking your I-9s, looking at your paperwork, trying to determine if you have individuals on your payroll who don't have work authorization, perhaps coming on site and looking for an individual who the government seeks to detain, relating to, their employment or maybe a criminal infraction. That's the next week. But this time, in this presentation, we're thinking about, what it means to employ with the goal, which is the case for all these presentations of compliance with the federal laws relating to employment authorization and verification. So, we're kicking this off, and this is, kind of the employers are part of this. And it's interesting too, because you're on the hook around this, and these are considerations and issues whether or not you are an employer who seeks to sponsor foreign workers. And employers fall into a lot of different categories. There are some that are unable to fill positions with the U.S. workforce, so they say, I'm going to affirmatively sponsor a worker. I'm going to file a petition so that I can have somebody come and work. Those are one bucket of employees that you might have that have temporary work authorization. The employer has said, like, yes, this is our deal. We are affirmatively saying we want to sponsor this worker. We're, doing the paperwork, we're doing the filing fees. That's, the primary part of my practice is I work with employers who say, I want to hire a foreign worker. What's the option? What's the strategy? Let's execute it. Let's bring them in and have them working. There are other buckets of workers that, employers, even if you're not one that says like, yeah, I'm ready to sponsor somebody, there are people that are likely, applying or working for you who have temporary work authorization that they're getting, essentially on their own, through a different immigration category other than an employment sponsor category. They are applying for a benefit in the United States that affords them work authorization. They are here in a status that is either, work authorized incident to that status or allows them to apply for an employment authorization document. They're here and they're allowed to work, but it doesn't necessarily require the employer to sponsor them. It does require the employer to know that. You do that through the Form I-9, and then to re-verify the employment authorization when the work authorization in the category is short term. So, circling back to the I-9, when we're thinking about our categories of employment authorized workers, the Form I-9 in Section 1 says, to the employee, check your box to tell me and tell the government, what your citizenship or immigration status is. Are you a citizen of the United States? That's box number one. U.S. citizen, like you're still doing the I-9 because you've got the paperwork requirement. You don't let citizens work without doing the I-9 and verifying it. This applies to everybody, but you're not going to come back and check the work authorization again of a citizen. Kind of that's like done and dusted unless they give you a receipt. A non-citizen national of the United States, see instructions. I'm not even going to talk about that because that's so, kind of so uncommon. It's usually like an outer territory that you are able to claim that, but very, very, uncommon. But if you have somebody who checks the box, see the form instructions. A lawful permanent resident to the United States, that's someone who's not a citizen but has gotten kind of a green card or their lawful permanent resident status. Again, that individual is a U.S. worker, not a U.S. citizen, but you think of them as a U.S. worker. And we mentioned this before, but I'm going to reiterate because it is confusing. You do not re-verify the employment authorization of a lawful permanent resident. Kind of full stop. Even if they have an LPR card that says it's valid for 2 years and says conditional lawful permanent resident. Lawful permanent residents are U.S. workers unless they've given you, temporary proof of status that, kind of needs to be checked in on. But when they show you that you're a lawful permanent resident, they're a U.S. worker. You don't circle back for that, even though lawful permanent resident cards on their face generally expire, on a date certain. And usually it's a 10-year period. And then the fourth category is an alien authorized to work. So those are the individuals who, for the most part, unless they're an asylee or a refugee, they're going to be able to work in the United States, but not permanently. It's a temporary period. And that's why you have the expiration date, if any. So, I'm here, I'm authorized to work until, December 31st, 2025. I'm telling you that I'm putting this information in, and then, I'm providing a data point if I'm, categorizing and self-identifying myself as an alien authorized to work until this date. And I would give my USCIS A number, my Form I-94 admission number, or, my foreign passport number and country of issuance. I would pick one of those and fill that out. And that's what I'm attesting to under penalty of perjury. So, employers have this, kind of first step, they're checking in with their employees and they're saying like, all right, like, are you authorized to work? How are you authorized to work? What's your category? And then, from the list of acceptable documents, what is your kind of your bucket of work authorization? From the type of authorization that you said you had, in the first page, what are you going to be able to give me? And this, I put this on partly because it gives you a little bit of flavor in terms of like the different types of workers that you might see. On your list A document, you've got a lot of documents that shows both identity and work authorization, and it runs to being a U.S. citizen or a lawful permanent resident. But you also in list A, you have employment authorization document that contains a photograph, Form I-766. That's the card. That's your employment authorization document card that you can get under a variety of different categories that we're going to talk about in a minute in the United States. So number 4, your employment authorization document, that shows, temporary work authorization. That's going to be presented by somebody who's checking that last box, on the section 1. And if you have an employment authorization document, you need to re-verify their employment authorization, and you'd set up a tickler from the employer's standpoint to check in with them on the date that they expire, and then you would complete the I-9 supplement B, with them because they'd provide proof to continue to work, either the same document or any document of their choice that's A or C to show I can keep working. On the list A too, you might have somebody who's here, kind of working with a specific employer, and then you'd have their passport and their I-94 document that shows, that they've been approved and admitted in that category. Examples of that are if you have an employer who sponsors an H-1B worker, you would re-verify them with their passport, and then their I-94 document has the name of the employer and the duration that the petition has been approved from. So a lot of those categories are petition based. An employer files a petition and their work authorization is restricted to the terms and condition of the sponsored petition. You're going to be using this category more if you are in fact sponsoring workers, more of an active sponsorship, kind of pre-start than, kind of just doing the form and seeing, and verifying that somebody has this work authorization that's temporary. And then the other categories, B is pretty straightforward for showing the identity. Again, as a quick refresher, the List A documents show identity and work authorization. So, one and done. If you have List A, you don't go to B and C. If you don't have List A, you have to do both B and C. List B is my identity and C is my work authorization. And interestingly, in the List C, you look at 7, employment authorization document issued by Department of Homeland Security. And then you're like, well, for Pete's sake, but what about how is that how is that different than the employment authorization document in List A, besides the fact that they didn't capitalize it? So you're kind of like, yes, like that is a very good question. And so it's, the List A, it references that form I-766. And, like, didn't she just say that that's a card? Like, yes, that's the name of the card, form I-766. So, think about the List A as your card, and I do think of List A, the capital employment authorization document, the EAD card. That's List A. List C is employment authorization document, and those are your kind of your lowercase. And this is more of a kind of a bucket of documents. This is a category of types of documentation that people can have that show work authorization, and that is intentionally left kind of like broad because the government wants some flexibility to be able to give people work authorization, without having to update the regs. So they have this kind of like catch-all category that, depending on kind of what's going on, you might see different flavors of work authorization. You're still likely going to be re-verifying that category, but it's going to depend on the document. So, what lives in that category are naturalization certificates for U.S. citizens. You wouldn't re-verify that. However, there are, kind of more flexible categories, like when the government was allowing, people to be paroled into the country from Afghanistan and Ukraine, there were, kind of temporary proof of documentation you could provide, for those individuals that allowed them to start working and apply for their work authorization. And they lived in that category. So, the bottom line for all of this is that there's a lot of different types of documentation you might see from individuals that are not U.S. citizens and may not even be lawful permanent residents or asylees and refugees that are coming to work for you. You may know about it on the front end when you're going through the hiring process. You also may not know about it. You might hire somebody, and if you, kind of just say to them, this offer is contingent on you being eligible to do the I-9, they might say, sounds good. And then they can show up and they can do the I-9 because they have work authorization in the United States. It's just not permanent. And it's something that you as the employer need to verify if you get to the point you're doing the I-9 and they present something that is, kind of a temporary period of employment authorization. So the employer has an ongoing obligation in some cases to continue to check in, and the tool for doing so is the I-9 and that re-verification. And we talked about this in a prior presentation too. Like this is helpful. You're probably like, oh my gosh, and I'm like, one more thing, and like, babysitting this and the reminders and the carrying on and the communication and like, yes, all of that. But if you from the employer standpoint are doing it and doing it correctly, it gives you cover for kind of like the liability that's not just doing the paperwork, but this whole concept of employing somebody that has lawful status. So if you are doing the I-9 and you check in with them and it turns out that somebody is not, employment authorized, you are not liable for that if you've done your piece on the form. It gives you this protection. Like kind of, and you can lose it if you get knowledge that somebody's not eligible to work. But doing the process is important because it gives the employer this rebuttable presumption that like my hands are clean. I did the form, I followed up with it, but it is really important to follow up because if you have not had a practice of tracking these employment authorization documents and doing the re-verification, then the government would say, well, that's on you and the employer because they gave you work authorization that was valid only for a certain period. And if they didn't renew it or they lost that status and you didn't ask them about that and they kept working, then you didn't do your piece of it to re-verify them. And you have somebody who you are liable for knowingly continuing to hire because you didn't check in with them and they've been working without authorization. So this is this is how, kind of like every employer is in the mix for, thinking about foreign workers. Your I-9 is going to be something that you have to complete. And because the I-9 has these categories that not all are US workers, every employer is in a situation that they may need to, kind of like accept documentation, follow up and re-verify whether they sponsor or not. And a lot of the individuals that come to you, kind of that you have not sponsored and that have work authorization, they are presenting that employment authorization document card. And the EAD card, that form I-766, you get that document if you apply for an employment authorization document using form I-765. And there are a lot of different categories of people who are eligible to apply for and get work authorization. So it's, it's a, kind of a catch-all card that's issued for people to show that they have work authorization in a number of different ways that they can get it, and the range is pretty broad. But what the government does is when you apply for that employment authorization document, it tells you, to put the category in which you're applying, and it relates to the law, to the kind of the types of individuals who are able to get work authorization. And then they carry that category over onto the card. So if you look at an employment authorization document, it'll say like, kind of like name, it'll have other, bio data pieces, and then it'll say that the category of the card, and that's listed on the face of the document. And sometimes that comes into play. We're going to talk about that in a minute. But I did, kind of do a screen grab from the USCIS website where they have listed these form I-765 categories, because I wanted to do kind of like an overview and just kind of give a, a flavor of the types of people who are eligible to apply for work authorization, and, kind of show how people might be coming into employment, really in most cases, if they're applying for the employment authorization document on their own, who are the people who are applying for and getting employment authorization documents? What does that mean to employers? So this screen grab, and I can see it okay on mine. I don't know if you guys are close enough or what it looks like, but it's the link to the site is on the left, this, government authorization USCIS link, and it has the categories, and it links to the form employment authorization, and that like I said, you put your category on it, look at the instructions to understand the eligibility, and then it says you might also find eligibility categories in section 274A12 title 8 of the Code of Federal Regulations. So these codes match the section of the regs for this. So it's like if the regs say, kind of in the drop down for like who can apply for employment authorization, these codes here are like they correlate with the section of the regs. That's where they're coming from. So, we have lawful temporary residents, we have refugees, we have paroled refugees, we have asylees, we have fiancés of people who are US citizens coming to the United States who can apply for it, different categories going through. And then the list continues. I could not fit it all on the list. So we have a few different slides on this, but there are, I think I will tell you, I think there's like 3 or 4 of these that go, but the list keeps going. So we've got deferred and forced departure, temporary protected status granted. This is TPS. This is the code 812. We're going to talk about this, kind of like in a little bit more detail. Categories like V, T, spouse of an e-non-immigrant. So, kind of like some sponsor categories, their spouses can work, some can't. Sometimes you have to apply for an employment authorization document. Sometimes you can. There's a lot of, there's just a lot of moving pieces around this, but these are categories that they're saying, kind of you could see an employment authorization document for. Spouses of A1 or A2, those are diplomats. So the spouse of a diplomat can come in and apply. Certain F1 students, not all F1 students, if they have applied for a card for this like post-completion optional practical training, if you complete a degree as an F1 student, you can apply for an employment authorization document to work in your field of study for 12 months. The next category, the F1 student 24-month extension for STEM students. If you have a STEM degree and your employer's in E-Verify, you can apply for an additional 24 months if the employer does a training plan with you and talks about training. So it's, kind of, they're kind of these blessed categories. Like I'm here in one of these ways, and I can apply for an employment authorization document, I may come to you for an employer with this card in hand and say, like, here it is for the I-9. Other students, J2 spouses, so the spouse of a J1 exchange visitor, asylum application pending, that's a big one. So I'm here in the United States and I apply for asylum and I have that application that's submitted with the government. It might take, kind of like years and years for that asylum application to finally be decided, as it works its way through the affirmative asylum process and then possibly a defensive asylum application process in front of a judge. That could be a very long time. Once you've waited a certain period of time after you filed your asylum application, you can apply for an employment authorization document. And that's, kind of that's in the news a lot, kind of like, oh, well, somebody's here seeking asylum, should they be able to get it like right out of the gate? They want to work, should they wait for a long time? How long should this be valid for? I think there was just a bill introduced that would limit the ability for asylum applicants to work. That's a category that is one that employers might see in Maine more than other ones. If you have an asylum application that's your pending adjustment of status application, that's another category. That means that you're applying for your green card. So if I'm married to a U.S. citizen and I'm doing the green card process, I can get work authorization as I go through it. It keeps going. It's still going. Oh, here we go. This is long, order of supervision. I actually don't even know what that means. Irish peace process, life legalization. There's a lot of different categories that you can see on here. Spouse of an H-1B, some can apply, some cannot. VAWA self-petitioners with an approved I-360. That's for domestic violence victims. There's a lot of categories that you could see. So, it's, kind of people are here in the United States and they are here lawfully and they are allowed to work and they will apply for this card. So as you're thinking about kind of like who you're hiring, people can come from a lot of different directions. And, most of the people on this list, they don't require employer sponsorship. They don't actually require you to do anything on the front end, but you are going to get a card that has a date certain on it. And you are at that point required to re-verify it. And, kind of like that's that's a rule under the I-9s, if that comes through. So that's, kind of like, kind of the lay of the land for the I-9. Depending on how somebody comes to you and they're at the point of doing the I-9, you complete the form, you check to see if they're employment authorized for a finite duration, and then, kind of like you move on. So we're going to pause for a second and we are going to talk about like, okay, wow, that's a lot. Like we're a half hour in. I just even talked about like a lot of the foreign workers, like what are we doing? Like, that was intended to, kind of like give an overview, especially for the employment authorization document categories of how many different types of work authorization, there is and how many people are in the United States able to work. And those are, a lot of cases you don't have sponsorship. So then you're just like, this is really stressful for me because I am in a situation where, kind of like I'm not in a position to sponsor somebody. Like I'm like, kind of like I'm not really ready to have somebody that I am going to expend resources. Sponsorship typically requires, some type of financial commitment from the employer. I tell my clients as an employment-based immigration attorney, don't sponsor somebody for a category of work authorization if you can find a US worker. It's not worth the overhead. It's not worth paying me. It's not worth paying the government, unless you have somebody who's filling a position. And this is actually a precondition of, kind of doing a green card process for many foreign workers or just a good, assessment from the business metrics. Unless you say this is a position I can't find for a US worker or somebody has a particular type of experience or skill set that you really need, and they're a rock star and you need them, kind of like don't commit or go through the process. Think about that on the front end. But then the question is like, okay, well, how do I know? Like, how do I know when I have somebody apply if they do require sponsorship? I can tell you one way you do not know is by looking at the CV and seeing a name that looks to be foreign or even, kind of a body of education or experience that, kind of like landed somebody outside the United States. Just because you have somebody who's applying and has a CV that shows that they might have gotten, kind of like a high school degree or an advanced degree outside the United States, or if it shows, kind of like perhaps a country of birth, if it shows, a name that does not sound like a name that would suggest that they were born in the United States, you just don't know. So you certainly do not want to be taking any action around, asking questions or making decisions or, kind of assuming somebody requires sponsorship based on, information that, kind of just suggests possibly somebody, is not a US citizen or lawful permanent resident, because we just don't know. Somebody might have been born outside the United States and they might be an asylee, a refugee, they might be a lawful permanent resident, they might be a citizen, because they were born here and, kind of like maybe went back to a third country and got education or came back in, or, kind of their name, kind of is not the determinant factor on that. So that's a very important takeaway, is that you want to be, kind of careful around this, because this is a situation right now that it's really hard for employers. We're going to talk about this. There's a lot of chaos going on right now because the Trump administration is taking steps to, kind of change the duration of people's work authorization. If you have temporary protected status, if you are paroled into the United States, you are given work authorization. And it's a, kind of a culture of, kind of like a focus on compliance and enforcement, and employers, are correctly focused on getting it right and checking their records. We just want to make sure that we don't, kind of like move in the direction of, kind of like creating risk of discrimination, by being like, kind of like, kind of too, focused on the front end, to the detriment of, kind of like what we're all looking to do is enable, kind of as many people to work as possible. So if you are, thinking about like, okay, I'm not going to sponsor, I'm not an employer that's going to sponsor, like that's a hard no, we're just not going to do it. How would I know? Or, kind of like it gets kind of tricky sometimes, because you're just like, okay, but, what if I have an employment authorization document and it's valid, but it expires kind of soon? Like, well, what do I do? I don't want to bring somebody on and train them, and invest a lot of resources if this EAD that doesn't require sponsorship now, but might in the future expires really soon. Like, how do I figure that out? And that's hard. Like this is, kind of like this is a difficult issue, but the way that, most employers would think about this and, kind of try to, figure this out kind of on the front end to help manage the process and related risk, on all fronts, is to think about asking it, kind of like in the application process. So, many employers have on their application already, are you legally authorized to work in the United States for any employer, or some variation of it, are you work authorized, can you complete the I-9, are you employment authorization? That's the threshold. And that's, kind of a hard stop if somebody says, no, kind of I'm not legally authorized, because every offer of employment is contingent on being able to show the employer that they're work authorized and complete the I-9. Kind of full stop. What a lot of employers will ask as a follow-up, if they are kind of like looking to get a better understanding of what, kind of like you might come up in the future, especially if somebody has a short-term employment authorization, but then might come to them afterwards and say like, oh yeah, but kind of like I need you to do something for me to keep working, is to say, will you now or will you in the future require employment visa sponsorship? So, it's a two-part question in some cases. Are you employment authorized to work? Will you now or in the future require employment visa sponsorship? And the latter part of the question is really intended to provide some insight into the, kind of the longer term needs for individuals who might be going to an employer and asking for sponsorship down the road. So a common scenario for that is the F1 student scenario, where you have completed a degree program, you're eligible to apply for an F1 optional practical training employment authorization document, get it for 12 months. And it's, kind of a relatively open market work authorization document where you're looking to get training in the field of the degree that you completed, but it's only valid for a year. And after that year, unless you have, kind of like something else in your back pocket, like you are, going through a process that, kind of is in a category that is individual to you, getting a green card through a spouse, maybe like, kind of like seeking asylum on your own, like something that allows me to kind of like do it on my own. In a lot of cases, employers, might have that employee then come to them after they get started and they do the I-9 and say like, I want you to put me in the H-1B lottery, or we need to do a STEM OPT EAD training plan to continue to work, kind of like, and employers are sometimes caught off guard by that, because they're just like, wait a second, I asked if they were employment authorized, they were, but now here I am. And like, oh no, like, like I don't want to lose this person. They're great. What would that look like? The two-part question is one that allows you to try to get some additional insight into kind of like, what does it look like after the I-9? Even if you're able to kind of on day one do employment authorization, is there going to be some type of like, kind of transition period afterwards where in order to keep the person working, the employer needs to do something, and this is, kind of a process that probably in many cases will also kind of like tease out people that are in a category now that might have employment authorization through temporary protected status, but their country of the TPS has, kind of ended or will end, so they have work authorization that's good for a date, but the government said like, kind of like done after a future date. At that category, they should be saying like, like I might need sponsorship in the future unless they have something else going or, kind of give you that, kind of that insight. These categories have been blessed by the Department of Justice Immigrant Employee Rights Group in terms of saying like, all right, these screening questions, like, like we're on board with them. Your employers aren't going to get in trouble if they ask these. You do want to though be consistent. Again, you're in your best position if you're asking everybody the questions. If somebody says like they discriminated on me based on my name, you're like, no, I didn't discriminate on you based on your name. We asked everybody the same questions. Employers are not obligated to sponsor. So if an employer develops information that says sponsorship is required, like they can say no. Like, like I'm really sorry, we're not sponsoring this position for an H-1B. It's not eligible. We can't move forward. That's within their rights. Every employee or applicant in the United States under our discrimination laws is protected under national origin discrimination. So that, the one thing that you want to be careful around if you're asking these questions is to make sure that you're not developing information in a follow-up. If you do an interview that gets a lot of, kind of like detail around where somebody's born, if that's not going to inform your hiring decision, or, kind of suggest at some point that the information developed gave you information about their national origin, and that was the basis of the termination decision. Like you ended up not giving them, or the kind of the decision not to hire. So you end up not giving them the offer, and they're just like, oh yeah, but we had a call and I told them this was my country, and I really think that they don't like people born in this country. Probably not, kind of really high risk if the screening questions are used consistently and it's clear in the conversation that you're developing information to understand what this looks like. But you do want to be careful around that. And kind of like it is important to be thoughtful and not allow, kind of your recruiters, your HR to, freestyle to some extent and just ask, kind of whatever they want, at any point. It's good to have some, kind of trained individuals doing this so that you don't, kind of go down a road that creates any type of risk. And in the, kind of the conversation around sponsorship, it's interesting because just like, well, what is sponsorship? Is it sponsoring an H-1B worker? Where do we expect people to say yes to that question? How are we thinking about it? My position is that, sponsorship is really anything that an employer has to sign off, not just if it's going to cause them to have to like, kind of pay for an immigration benefit. So, kind of in some cases, kind of there might be a differing opinion on what sponsorship involves. If you have, for example, an F1 student that wants an employer to sign off on a training plan to get them the STEM OPT EAD, and they're just like, well, it's not sponsorship because you're not paying a fee. I think employers have a good position that they are, making representations under penalty of perjury on a training plan that's required for that. So they are sponsoring, but for an employer taking action, if somebody's not going to get the status, the TN category is one that you see, a decent amount in Maine. The TN is a work authorized category that's available for citizens of Canada or Mexico under what was NAFTA and is now the USMCA Free Trade Act, that you are, allowed to hire individuals who are professionals in TN status if there's a qualifying offer of employment. And the employer, it's a relatively light lift. If you have somebody coming across the Canadian border, the employer can provide a letter confirming details, and the employee can come in, not a heavy fee, kind of associated, but it's still sponsorship in my mind because the employer is giving the letter, and there is some liability for employers, when they have foreign workers that, kind of would be avoided, but for their taking action on this. So, these are questions that, kind of like, are I think a best practice to be putting in. And it's worth, as a takeaway from this training for, kind of employers to think about like, how do we ask on the front end, in our application process that individuals are able to work, and then, kind of like, do we take it this additional step? Do we develop some more information in the hiring process? So we have we actually, this is our last step, our last slide, and I'm going to get to some of these questions. A lot of the questions in here relate to things that we're going to cover. So we have these situations that we have the kind of the I-9's done. You've done I-9, you've completed your point. It might require a re-verification in that are kind of checking in with them, kind of based on the date of their document expired. So, kind of at the point that you're doing the re-verification, it can be, kind of a little bit difficult sometimes because you have kind of like just as wide of a universe of work authorization documents that might come up in the kind of the re-verification as you do in the initial verification. A lot of combinations, and a really important takeaway from this training also in the re-verification process is you want to convey to the employee that you're re-verifying the same information that you did at the point of hire that says, I'm an employer. I am federally required, I'm legally obligated under federally laws and federally mandated to verify or re-verify this employment authorization document. That's why we're doing this. I will accept any document or documentation of your choosing to show me you can continue to work, or, that you can initially work that's acceptable for the I-9 process. And I mentioned that just because you don't want to have a situation that you get in trouble because you're just like, all right, like, kind of John Smith did an I-9 with an employment authorization document in this category, initially. And then when I went to re-verify him, I said, like, John, I need a new I need a new EAD in the same category, because I'm re-verifying one that expired. Like it kind of like you can see where it makes sense. You're like, all right, I'm checking in for the new version, the extended version of what you initially gave me. In fact, John might have, kind of at some point changed his category of work authorization, and that's okay. So you might have somebody who initially applied for the position and presented proof that they have an EAD with a pending asylum application. Maybe over the course of the duration that, kind of you had the I-9 on file, they got their asylum application approved. Great. You would take additional documentation that shows that they're able to work, that they present that shows they're an asylee. You might have somebody who's become a lawful permanent resident, over the course of the period that you needed to re-verify. Great. You might have somebody who had like multiple irons in the fire, and they are needing to re-verify. Great. So, out of the gate, you're in a situation that you're just like, all right, your choice, what you need to present. It can be challenging in some cases when you're doing the re-verification because the government is in some cases, especially for employment authorization documents, slow to process renewal applications. So, there was a period of time that those renewal applications were going very slow, especially during the pandemic. So you can apply for a new employment authorization document up to 180 days before the current document expires. And in some cases, the government was taking like 9 to 12 months to process the renewal application. Everybody's like, well, that's bonkers. Like, if you can't allow people to apply outside of 6 months and it's going to take you like 9, 12, like, oh, even longer to, process their application, like, what are people supposed to do? This is really unfair. So the government, and, kind of like to their credit, in a lot of cases has looked at it and said, like, all right, we see this issue. We are going to create some categories for employment authorization documents that allow people to keep working based on the timely filed extension application. So if you filed your renewal application before your current card expires and you are in certain categories that this applies to, you can use as the employer evidence that their current employment authorization document has been auto extended by the renewal application. And that evidence is outlined in the M274, and it's, applicable to some categories. It's a little bit different for the F1 student who has a pending STEM OPT EAD application. So like, it's always good to check to be like, all right, like what's my record? What does the M274 say? Like, what do I need to say? And like, kind of follow those instructions to make sure that you're checking the boxes and you are, properly re-verifying it. And then, what you're doing is you basically have kind of like a Band-Aid, kind of piece of evidence here that you're like, okay, like, this employment authorization document has been auto extended, I need to set a new reminder, based on the government guidance of like how long the auto extension period is. And then I'm going to, re-verify with the employee the fact that this document has come in, by that date. And if the employee comes to me earlier and says the government's made a decision on this application, then, I'll re-verify with the approval. Or if they're just like it got denied, then it's like, then that's the end of that period. The other document doesn't get auto extended forever. So, you're doing the re-verification for employment authorization documents. You'll frequently get people who are coming to you and saying like, yes, I have an auto extension, kind of like we're going through. One of the questions in the chat is a really good one. It says, if an employee has re-verified their status with the receipt that gives them the extension of their EAD, what happens if their renewal is denied and we weren't aware? That's a really good question. So, this goes to the knowledge component of, this presentation and thinking about like, well, what are employers liable for? What are they supposed to do in this situation? If you have a situation and the employee has a denial of the employment authorization document, and they don't tell you, that's a them problem, not a you problem, unless you get knowledge of that denial that they have given to you, kind of like at some point. And the question says, and we weren't aware. So at that point, kind of like I do not think employers have the obligation, if you have an auto extended EAD, to check in with the employee, kind of like I really don't think at all. I think it's the employee's obligation to tell the employer. You don't have to call them every day and be like, any word. And like, I also don't think it's the employer's deal to, kind of like take the receipt number and start running it through the USCIS website and seeing, kind of like if there's any action on it. If you didn't know, you don't have any knowledge that anything changed. So you couldn't take action to terminate the employment because you did not have the knowledge. So at that point, the employee is, kind of like, running into issues with their immigration status because they are working without employment authorization, which has negative consequences for their immigration, status, their ability to get certain benefits in the future. From an employer standpoint, they're not going to be, kind of on the hook unless and until they get notice that that denial has come through, some type of knowledge, and the knowledge can be actual or constructive. We'll talk a little bit about what that means, or you run into the, kind of like the date that you need to do the re-verification based on the auto extension period, and you sit them down, they're like, okay, like, now we need proof that you can keep working. They're like, I lost it. And then you're just like, well, then you're terming effective today because you don't have continued work authorization. So it's a tricky question, and it's very relevant today, and it's very, very difficult because you're just like, okay, when do the employers, when is it the employer's deal? If I have somebody who has this work authorization and it's vulnerable in some way, when do I need to take action? Employers are generally not immigration attorneys, they're not experts in the field. And we talked about before, the standard is actually like kind of low, kind of what's the employer obligated to do? They are obligated in the I-9 process, on a reasonableness standard to verify that the employment authorization appears to be genuine and relate to the individual. It's a reasonableness standard. And I feel very strongly that the reasonableness standard would extend to employer obligations during the period that the person has, the authorization to work that's completed on the I-9. And that is, kind of conditioned on the employer not getting actual or constructive knowledge that the person's not authorized to work. So the actual knowledge is, pretty straightforward in some cases. So if, kind of Katie Clark is my boss and I come into her office and I have been, kind of like in a category that I have, work authorization, and I come in sobbing and I tell her like, I'm just really devastated, this application got denied, I can't work anymore. If Katie's my boss, she has actual knowledge because I told her I cannot work anymore. So she can't be like, well, we've got the I-9 on file for you, so you're good until that date. Like, she knows that I can't work. She has actual knowledge. So you have gotten knowledge, kind of that the person can't work. Constructive knowledge, is a little bit trickier. So constructive knowledge, like, what does it mean? It's just like, well, if, kind of like, I didn't tell her, but she, has started to hear, like, maybe she gets a, kind of like a report from my coworker that I told my coworker I can't work anymore, kind of like that probably, depending on the, kind of the veracity of the source, that probably requires at least, some type of investigation. And that, I would say, I think that that is different than, kind of like an anonymous complaint that says like Katie Minervino is not work authorized. But I mean, depending on the circumstances, like it's the constructive knowledge piece of it is going to be fact specific. One anonymous complaint in a vacuum is not likely going to be constructive knowledge. However, kind of like if you have, kind of like if you're hearing rumors, if you hear that rumor in connection with getting a Social Security no match letter that has my name and Social Security on it, some type of kickback from the insurance company that my Social Security number failed a test, kind of like other, like, kind of like depending on the circumstances, it's going to be, kind of on the employer to, kind of like make a decision whether or not there needs to be any type of follow-up relating to it. And one really important concept on, a lot of this, like, kind of knowledge piece and the re-verification, if you are checking in with an employee, during the duration of the employment authorization that you have in the I-9, is that you're generally going to re-verify preceding the termination. So if you hear, something that comes up that you're not like, 100% sure is accurate, you're, going to go to the employee first and say like, this is why we're meeting, and, kind of, it might be a situation too that you're just like, oh gosh, like, like I did this training and I realized that we have a whole bunch of people that we hired and we didn't set reminders and check on their employment authorization documents. Like you sit them down and you don't say like, you're all out. You sit down and you say like, I need to check in and have evidence that you're continued to be able to work. I'm re-verifying your employment authorization. Do you have something that you can give to me that shows that you can continue to work? And then if they do, great. Continue to employ them, update with that record. You wouldn't term. So out of the gate, you're essentially like giving the employee an opportunity to show that they can keep working, and kind of having that conversation before you would outright term. And this is a situation that employers are in a very, very difficult predicament, at this point, because not all work authorization in the United States and not all, categories of people in the United States are created, kind of equal. So there are people that are in the United States and they're in, kind of like a particular status. So they have been approved in a non-immigrant classification. That means they can stay here temporarily and they have, F1 student status. They have H-2B status, work authorization. They have H-1B work authorization. That is a status. There are other people in the United States and they're allowed to be here, but they don't have, kind of like the same, kind of like, kind of grounding and status, but they've been, paroled into the United States. So they're just like, all right, you're allowed to come here. We're, going to allow you to come. In many cases, we're going to allow you to keep working. And that's a parole. Those are your parolees. There are people here who are here and they might not have had any status, they might have had a different type of status, but something's happened in their home country, which it was really bad from the government standpoint. And they're just like, all right, like, if people are here in the United States from one of these countries, we're not going to require individuals from those countries to go back for a certain amount of time while the conditions are still really bad. So we're going to give them temporary protected status. So, it's called TPS. So, I'm here, kind of like I'm from, Venezuela, I'm from Haiti, I'm from El Salvador, I'm from, Sudan, a country that's on designated temporary protected status list. I'm not going to be, kind of like removed. It's not like, it's not the ability to stay forever. By definition, it's temporary, but I'm going to be allowed in many cases to work if I apply for my employment authorization document, if I'm, kind of in TPS. So those are, kind of like categories that have been on the news, and they are categories that are, kind of like more vulnerable to changes happening and, kind of subject to continued basically permission to stay in the United States from the government, either because, they've been admitted individually or part of a program that's just like, all right, we're going to, kind of let you in for a while, kind of like it's not permanent, but we're going to allow you to come and stay. We're going to parole you in, or you're here and we're going to give you this temporary protected status where you're allowed to stay for a period of time, but the government gets to kind of decide if it's going to be extended and how long it's here for. And the Trump administration is, kind of like taking action to start to limit the ability for individuals who are here in these kind of like gray area statuses and basically saying like, this is done. So for, people who were here in the United States and they might have otherwise, come into the United States and entered without inspection, for a while there was a program that you could apply in the CBP One app and, kind of basically like present and say like, all right, instead of like, trying to like, kind of like, sneak across the border, I'm going to make an application. I'm going to show up at a US port. This is all going to be part of a process. And then that you're going to let me in and then I'm going to like, going to go through the asylum process while I'm here. Like that was a CBP One at port parole. There was a program that the Biden administration did for individuals that had like high volumes of people coming from countries that might have otherwise come in, entering without inspection and kind of not being inspected at the border. The CHNV parole program was intended to allow those individuals to kind of say like, I'm coming anyway. Can we please like kind of get on the record? Can I come in? Can I work? Can we be part of this program where I'm paroled in? Trump administration is saying like individuals who report paroled, like ending that, the CNHV program, like wanting to end that. You've probably seen a lot of announcements around like, that like TPS Venezuela ending, TPS Haiti ending, kind of like we're ending it on this date, and that date might be earlier than a date that was previously said, or we're just saying we're not going to extend it further. And that's, kind of these announcements are, kind of like very devastating for the individuals who have this status because they're here lawfully and they are work authorized. So this isn't a situation that you're just like, oh, kind of like, I expected this. Individuals who are here are in approved periods of stay in the United States, and they've been given employment authorization documents that they have presented to employers, relating to their status and their ability to work. And it's, kind of like it's very in flux because that duration has, kind of like been documented in that category. In some cases for, a lot of people with the same date, if they were in temporary protected status for a country, it might vary depending on, kind of like the date that an individual was paroled in. But the commonality of a lot of what you're seeing in the news is that the administration is saying like, we're stopping it, we're limiting it, and we're telling individuals through these federal register notices that we're expecting them to be done. In some cases, you're saying like, all right, here's your date. Like, we're going to give you a period of time to upload information into a government website and say you can continue to stay. And they're, kind of like, that all of these announcements are also kind of like adding to the chaos. So many of them, if not all of them, have been like challenged by litigation in the courts. Sometimes there's an injunction. The Supreme Court might be involved. So it's just like it is, like it is crazy confusing in terms of trying to track and understand all of this. And then the question is like, all right, what am I supposed to do? I'm just an employer. I just did the form. Like, I don't know. Like, I don't know. Like, I just have this EAD. Like, what, like, kind of like what's my deal? Like if they keep working, like, is it on me? Am I supposed to check this? Like, how do I know like what's going on? I think, most employers at this point, kind of in the absence, and I can tell you there really hasn't been anything of some special directive from the government that says like all employers have to take action on, by the state and look at this date for their I-9s for their individuals. Like employers, I think are generally in a situation that you kind of like you sit back and you trust your I-9s. If you've done the process, you have clean I-9s that have an employment authorization date, and it's essentially going to be on your individual employee to, kind of come to you and tell you if their work authorization has ended, and needs to take some type of corrective action or needs to stop working because it's ended. And, at the end of the day, there are a lot of situations where people might have, for example, been paroled into the United States and then also applied for asylum while they were here. Or you might have somebody who has temporary protected status and also a different status. So you don't necessarily know for an employee who might have an employment authorization document with a category code that corresponds to being paroled in. That's C11, and that's both your port paroles and your CHNV parole. So like, how do you know which is which? You might have somebody that has TPS and it, kind of like it needs to, kind of like it's going to end, it's been announced, but you're in a situation that you're just like, they could have something else. So, this really, kind of like is intended to communicate that there are a lot of moving pieces and you're seeing a lot of it. And it's very challenging for employers in, kind of assessing what their action is going to be. Are you going to just kind of be like, all right, I'm going to wait this this out. I'm going to wait and see what happens. And it's going to be on the employee to take action in the absence of any really clear directive from the government that I would reasonably be inspected to know about. If I'm a small employer and I've got one employee, like, am I supposed to be like reading the Federal Register on the regular to kind of figure out what's going on? Again, all of this is kind of like, it's a big mess and it's a big mix. So you're like, kind of like, all right, like, I'm going to kind of be hands off on this, and I'm going to wait until have the employee tell me, like, well, what if the employee does come to you and says, like, I'm stressed, kind of like, I don't understand it, like, kind of like your knowledge, kind of like in your ability to say, like, kind of like kind of like I didn't know they were ending, is going to depend on the facts. It's also going to depend on the employer. If you're an employer that does the I-9 and doesn't keep copies, like, you just did an EAD and you don't know what category code it was. How would you be able to tell? If you're an E-Verify employer, you are required by law to keep copies of employment authorization documents. At that point, like, you could probably check the code, but like, is that on you to do it? Probably not. Where some employers are being more proactive tend to be, they're worried about their workforce, and they're worried about being able to kind of like keep the doors open. So if employers know that they have a large contingency of TPS workers from a particular country, they might be more inclined to, be monitoring these issues and, kind of more proactively start like thinking about, kind of like communicating, planning to backfill, kind of like how are we going to manage, kind of all of this. But it's an environment which I have not really seen before to the extent in almost 20 years of practice, where there's kind of these categories in this employment authorization for individuals that have been granted and are being taken away, in some cases earlier than was anticipated. And that is, kind of both devastating for the employees who are working and very challenging for the employers, because you're just like, I don't know. Like, I didn't sponsor them. Like, I just did the I-9 and they came on site, and like, we're just trying to figure this out. And kind of like, how should I be handling this, kind of on the front end? And it is, kind of, it's a very, very difficult time. So, what you want to do is just want to kind of like be reasonable on it. You want to monitor the situation. Are you getting information for employees that would give you actual or constructive knowledge? One thing that is, kind of wild, relating to all of this too, is that the government has actually started going into the E-Verify system and posting notices for employees who they think have lost their work authorization that was, kind of used initially when the I-9 was completed and the employer put them into E-Verify. So E-Verify has this like section on its website of like alerts, and it tells employers individuals who are coming up for re-verification. And that's like kind of goofy, because you don't re-verify somebody in E-Verify, you just re-verify in the I-9. So they were like, when it first started, they were like sending out alerts, and that like, like reasonably like resulted in employers thinking that they needed to go into E-Verify and update the work authorization, because they're just like, I don't know, I got like a notice from E-Verify, and E-Verify is like, no, we just wanted you to know. Like, it's not a process. We're just telling you. And everybody's like, "Ugh." But it is. So E-Verify, like, kind of what they do is they're like, kind of like backup tickler system. They're saying like, all right, like, you're an E-Verify employer, you put information in at the point of hire for your new hire that shows that they have temporary work authorization. Like, here's the people. Don't use E-Verify, but just in case you need a backup like list, they're starting to feed in, kind of like, if they're saying that there's, kind of like some type of loss of that employment authorization through these programs, they're adding those names onto the program, which is, kind of like entirely unprecedented and kind of wild. But I think, arguably is putting employers more in the hot seat in terms of like knowing that certain individuals have lost their work authorization because they are E-Verify employers and they're getting these like lists. And again, the loss of work authorization doesn't mean like full stop term somebody. Like, if you have somebody on these lists, I think you'd at least have to take action to re-verify their employment authorization, and say like, all right, like, we got this notice from E-Verify, just checking in, are you able to keep working? So it's going to be, there's not going to be one size fits all on all of it, but kind of like, just to kind of like, kind of like reiterate, like, a lot of this, circles back to the I-9. Like you're in a much better position if you've done the I-9. It's a, kind of a snapshot of a moment in time. You double check somebody was work authorized. You have a re-verification reminder, by that expiration date. And then, what happens in the meantime, is going to be really dependent on their classification of work if they lose it. And then also, kind of like what you as the employer were reasonably expected to do in the meantime. And that's going to be driven largely by, kind of the facts. Are you as an employer, kind of like, are you resourced to, kind of be expected to understand this stuff, to check this stuff? How big is your workforce that would relate to your, potential liability if you did have somebody who lost work authorization, the government for some reason thought that you should have been aware of it, but a lot of it, like again, that the I-9, like while it's a pain, it is also a tool to kind of create that framework and show that you're doing your thing by checking in. And again, before you jump like right into being like, oh, I saw a TPS from Haiti is going to be termed like full stop, or, they're not renewing it for this country. Like you're done in the state, you check in and say like, all right, like, kind of like, here's the information. And, kind of like, I'm going to check in, like, this is a re-verification. I'll take what you can give me. Do you have anything else? And, in some cases, unfortunately, individuals are not going to have additional work authorization to present when they lose some of the status. And, employers may have to terminate if they are not able to confirm that somebody has continuing employment authorization, if it comes to the date that the re-verification is required.
Katie, thank you so much. It's a lot to manage right now as an employer. I did want to manage the remaining time and go through some questions. As you look through some of the questions in the chat, I did want to ask you, you mentioned that I-9 is certainly process, but it can be a compliance tool for management. And really, short of uh, monitoring the Federal Register, are there any additional or kind of um, lower barrier informational channels that you'd recommend employers to, they that would give them some idea of what to continue to become more informed on these topics?
Yeah, but I mean, I think, kind of there's a lot out there right now. Like the TPS stuff is getting a lot of news coverage. So I think like, the Federal Register is the source of it, but kind of I think your point is a good one too. Like, that it's not just that. Like, if you're monitoring the news, you might not have before this really kind of like understood, kind of like what it meant if you were seeing news updates that say like, kind of like people are upset that the Trump administration is terminating like parolees work authorization, or that the temporary protected status from, a particular country is not going to be renewed. The interplay between, people who have EADs with these codes, and this was the basis of their work, and these announcements might not have come into focus. There are a lot of, kind of alerts being, kind of sent out also though, like in just posted through like legal service providers, law firms, some are, kind of like more active than others in saying like this is what's going on, kind of like here are real-time updates. A lot of, kind of like nonprofits that, support individuals who are in these categories will be posting information and alerts. So I think, it is an area that is like very challenging to keep up with. And there are, kind of like, like when you Google it, there are, kind of like, there are good resources out there for those who are inclined to kind of like, watch, kind of like all these categories, the issue, or maybe some categories more than others, depending on your employee population.
In listening to your response, maybe this is something that we can work on together to maybe provide a quarterly update
Yep.
following these webinars. It is a lot to manage, and I will be the first to say that it's usually not a great use of time for everybody to be reading the Federal Register. So maybe we can be a little bit more efficient.
Yeah. When it's wild
Katie,
too,
do you
because
want
you
to
don't know.
turn?
You could
Go ahead.
you could
Yeah.
get in, you could get like you could see the Federal Register notice and you're just like somebody's probably gonna sue. So so at that point you're just like, yes, I see that, but is this a certain thing or is there gonna be an injunction that requires us to like, kind of like pause anyway. So it's like, it's not only kind of like keeping up on the notice, but also kind of like seeing, whether litigation impacts, the final determination also, which makes it even more difficult.
Okay. Katie, you want to try to make sure there aren't any unopened or unaddressed questions?
Yep. So one question, is it possible that an employment authorization document category CO8 would ever require sponsorship? Let me just double check what CO8 is. And I do want to say one thing, kind of like as we're going through this and thinking through all of this, like, so you have kind of like you have resources from an employer standpoint too, like in checking the M274 and running all of this. But sometimes when you're running through all of this, you get an employee that you bump into that is adamant that they're allowed to work, based on what they have. And you might be adamant based on your information. You might be talking to an immigration lawyer that is adamant that this employee is wrong. So you're kind of like, what do I do? Like, so you have somebody that's just like, like, oh no, like I'm eligible for an EAD auto extension. And you're just like, your category codes don't match. Like, it's you're auto extending in the same category. And there is some overlap if it's TPS, but like, what do? If you're just like, this person is telling me that like I'm discriminating against them by not allowing them to work. And I'm really struggling because my understanding is that I can't, like you don't have to kind of like, you don't have to let the employee force you into letting them work, if you're telling you can't. One interesting thing that you could think about, and I just want to throw this out there as a resource, is the Department of Justice Immigrant Employee Rights Group. They have a hotline. And their hotline is staffed by attorneys and also staff. And it's, kind of intended primarily to get complaints from individuals. So if you have somebody in like, I'm like, Patrick, you're just not letting me work and you hate my documents, and I'm going to call the Department of Justice Immigrant Employee Rights Group and I'm going to like bring a charge, like that can be really stressful. If you know that you're right, or like, there's some kind of confusion, sometimes you might want to think about saying like, let's call them together. Kind of like, if you are so certain about this and I am so certain, like, let's call them together and let's let the Department of Justice tell this aggrieved individual that they are wrong and that they have no claim to bring. I say, kind of think about using that sparingly. I don't think that you would call a Department of Justice Immigrant Employee Rights Group like just like all the time and be like, hi, I'm employer A. I think I'm discriminating. Like, what should I do? Or I'm not sure if I'm discriminating. You don't want to kind of like feed them information about potential investigations, but it is an interesting resource if you have, kind of a one-off and you feel like you're being pressured by an employee who's wrong on the I-9 stuff, to call them and be like, all right, kind of like, what do you think? In a lot of cases, they'll be like, employee, like you're wrong, the employee is right, and that gives you that cover. So the CO8 employment authorization document is somebody who has a pending asylum application, and they are, kind of eligible to work with a pending asylum application. The question related to like, would they ever require sponsorship? They might ask for it and they might need it. So a lot of people that are here in the United States, they're looking to get every avenue possible for their ability to stay. So when I mentioned like, yeah, you might be losing your work authorization in one category, but kind of like you go to them and they're like, yeah, but I also applied for X or I also applied for Y. So if you have somebody who has a pending asylum application, not every asylum application is ultimately going to be approved. And sometimes they take so long that your case might get weaker because of changed country conditions. So kind of you could be in a category that you are able to say no if you have an employee that has a pending asylum application. But in some cases, they might ask, and in some cases, the employer might say yes, because they're just like, oh, there is actually a category 2 sponsor, and I would like to keep them. I will say, very briefly too, the categories to sponsor workers are relatively narrow. So when you're thinking about kind of like, all right, like, kind of like there are people here and they're losing their work authorization. I don't want to lose this employee. Like, what can I do? It's worth, thinking through whether you have the ability to sponsor them and keep them. But the way our laws are structured, there are limited options to sponsor workers, and most of them, kind of trend to the professional workers. And in some cases, cases, those aren't even on the table. So the H-1B category, which you might hear about, those are for individuals who are working in specialty occupations and their job requires a bachelor's degree or higher. And this requires the employer to pay for the process and jump through a number of hoops in terms of like providing notice and all of those things. If you are not an exempt employer from the H-1B cap, and most employers aren't, and you haven't held a H-1B before, you literally have to win a lottery to be able to get a new H-1B because we have a congressionally mandated cap on the number of new ones per year. There are other categories, but a lot of times, like the hard thing is that employers want to help, but there are no options to help them. In some categories, like even if you can get through the bureaucratic headache. So, there was a question when we were prepping for this, like, can we talk about H2s, at some point? And like, yes, the H2 category is intended to allow employers to bring temporary agriculture workers or temporary non-agriculture workers. So the H2A are agriculture workers, the H2B are non-agriculture, where there's some type of intermittent need. So the idea is that you're filling in gaps. So in Maine, if you have a seasonal need for workforce during the summer, you can bring in H-2B workers to help supplement that. And those individuals are intended to go back, to their home countries during that period. And there's a lot of, red tape at these different steps where you're providing information to the Department of Labor, you're getting clearances from them, they're coming in. That whole process kind of works together. And they're coming in, conditioned to the terms of the approved petition. So those are kind of like your, kind of your workers who require the sponsorship, and they're kind of like they're tied to the terms of the petition that was sponsored. So, there are, these categories of workers that run to self-petition, and then there's the other universe of people who are sponsored. And our system is just really fundamentally broken and limited, and we just don't have the available options to meet every need and every ask. So there are some gaps into like what employers and employees want to do and what they're able to do under immigration law. And it's just a shame.
Well, thank you, Katie. Any other written questions that would be helpful to address now? Or I would also ask any of the participants if there are questions that might be easier to ask to join, please raise your hand as well.
Yeah, one of the questions is if you have an EAD card that expired in 2029, a driver's license and a social security card doesn't say not authorized to work, and all three are written down, do you still need to re-verify the EAD? I would offer not, because you have a driver's license and a social security card that does not have the restrictions, so their employment authorization, kind of like, incident to status, you're not work authorization. And I was, like it's like, I mean, all of this is really confusing. Like, when you go up here and you look at the categories of employment authorization document, you have these like 765 category codes, and two of them are refugees and asylees. So if you have a refugee and asylee present you an EAD, you have to re-verify them because they gave you that card. And, kind of like that card has an expiration date. And you're probably just like, she just like went off on the beginning of this presentation, how they're US workers and like they can keep working. And part of it is like, part of it is just the documentation that's presented, running from that. And the way I was thinking about this, and like everybody, like, please like humor me on this, but I was like thinking about that last night, and I was just like, what's a good analogy? Like, how should employers think about this? Like, kind of like checking in other documents and re-verifying it. A lot of it, like, runs to the type of documentation that somebody like, section 1 is this is how I'm authorized to work. This is my category. 2 is this is the documentation that I'm authorized to present. So the way I think of it, like if you're like a US worker, a citizen, kind of an LPR, refugee or asylee, and you present work authorization document that like doesn't need to be re-verified, so it's not an EAD for refugee or asylee, that's like giving somebody payment that's like your bank account routing number. Like they don't need to keep checking in. They just keep taking the money. Like, like you're like, this is like, this is like, this is like set, you don't continue to go. That, kind of then there's other like, other methods, when I was thinking about like, well, how would I explain, somebody who has an asylee or a refugee and they gave you that EAD and it needs to be kind of checked in on. I was like, that kind of feels to me like they chose to give you like one of those prepaid Visa cards that is not an actual Visa card, but you like pull it off the register at Target, and they're always like kind of a pain in the butt to use because there's usually like a pin involved, and sometimes they expire and sometimes they don't. You never know how much money's on it, and like some places take it and they don't. It's like it's a separate category, but it's like it's limited. Like it's not like a long-term thing. It's like of a limited duration, a limited amount, a limited use. And it would be like your vendor being like expires early, and this like TPS stuff. And it's just like, yeah, sometimes that happens. And this sponsored employment authorization category stuff, it's like the company card. Like you're only allowed to use it, when the employer gives it to you, sponsors it, maintains it, and kind of runs through. So, there's the categories of people who can authorize to work, and then there's the, kind of the proof that they decide to provide. And kind of asylees and refugees, like an asylee can get an employment authorization document and give it to you. They also can get an unrestricted I-94 social security number that's not unrestricted and give it to you as a list C. So you kind of like you run it off the documents that you have. And I will, if I didn't lose everybody entirely on that rant. One of the questions is, so you do an audit, you determine that you have someone missing an I-9. In order to correct it, do you start a new process for an I-9 with the old hire date, or do you utilize the date that you complete the I-9? You do a new I-9 in the current form version with the old hire date. Everything is like fully transparent in real time. And next week is going to be our final presentation. We're going to talk about like, all right, like, we talked a lot about this, like, what happens if the government comes and checks? We get our I-9 notice of inspection. What are they going to be looking for? How do we respond? What do we think about this? Like, what should we as an employer be thinking about in terms of like, communicating to our workforce about the risk of inspection? What are we thinking about? Kind of the short answer is like really not a lot. Again, we want to kind of keep separation, that we're the employer, we're doing the re-verification. If somebody's like not on the good side of all this, that's their deal because we did the form. But what if the government comes? What if unbeknownst to us, there's someone who has a criminal infraction, they're at the work site? How do we respond to those situations? But we like the key to all of this, and which was part of the prior trainings, is transparency. You don't want to look like you're hiding the ball. You want to do the forms. You always want to be clear if you are showing it. We have another question for the mergers and acquisitions. Again, you're going to be doing the kind of the merger and acquisition analysis, kind of like depending on the type of merger. If it's an asset acquisition, if it's a stock acquisition, is the new employer stepping into the liabilities of the other ones. The M274 on the USCIS.gov website do have instructions and some talk points about kind of what employers should be thinking about in an M&A context. So I would think about kind of looking at that as a starting point. We talked about if the renewal was denied and you didn't know. If you have an employee under the 812 category, which is TPS, has the approval notice and the 765 receipt notice, can they continue to work, or do they need to have the actual employee EOC to work? I don't know what EOC, I think it might be EAD to work. There are, the TPS rules are really complicated and really confusing in terms of like, and this was even before, the shortened periods, but generally there are, usually categories of time and workers who can continue to work based on, kind of like auto extended employment authorization documents as outlined. And, if you have a specific question, typically it's, kind of provided a pretty good outline on the TPS page of that particular country. And in the Federal Register notice, they'll say like, kind of like, we've announced on this date, these EADs are automatically extended on this date. And, kind of there's further guidance on that kind of runs to the country. So we've got 3 minutes left on our work authorized categories. But the bottom line is you're, as an employer, even if you are not, kind of affirmatively choosing to sponsor workers, you are going to run into some of the issues around, kind of foreign workers. And that's a good thing. Like Patrick said in the beginning, our workforce in Maine and elsewhere, we are better for having, kind of like a steady stream of workers, a more diverse workforce. Like this is a positive thing for our economy. And, kind of, I do not intend in doing this overview to, kind of like, kind of in any way suggest that this is something that employers, kind of are going to be prejudiced for having it. It's all good, but it does require, action by the employer to protect both the employer and, the employee, to make sure that, kind of, as I said in the beginning, we're fully compliant, as we move forward and cooperative, and employers are well positioned, with everything going on in case they do see any enforcement, because the stakes are high. And, that's going to be next week what we'll talk about.
Well, thank you, Katie. It is a lot of information to convey. It clear you have bring an amazing amount of expertise to this topic, and so relevant in 2025 with so many moving pieces. So please join us next week for our last webinar in the series of immigration best practices. We'll also be providing additional information on the English language opportunity for English as a second language training. And did want to again thank Katie and all of our sponsors for supporting this webinar series. Thank you, Katie, and we'll see you
Thank
next week.
you. Thank you.